So today it's all about severance packages and separation agreements. So I have a special guest with me, Brandon. Brandon, would you be kind enough to introduce yourself today?
Sure. Thanks so much, Sue. My name is Brandon Klippinger. I'm the founder of Klippinger Employment Law. I'm an employment lawyer, and separation agreements are documents that I spend a lot of time drafting and a lot of time reviewing and a lot of time negotiating. So I'm excited to be here and talk about them with you today.
Absolutely. I'm so happy that you're here today. So before we get into this robust conversation, Brandon, since we are talking about some legal things here on this video, can you share any disclaimers we should share with the audience today?
Sure. So just a note to keep in mind is that we're going to be giving some general education and talking about separation agreements in general terms. But if you're actually presented with a separation agreement or are considering requesting one, it's important to keep in mind that each case has its own specific facts. And so if you want to seek legal advice, it's important that you actually speak with a lawyer regarding your case. And the other thing I'd mention is that I practice in the state of Massachusetts, and each state has its own laws. Most of what we talk about today is likely going to apply to employees in most, if not all states, but each state can have its own specific quirks and requirements. So again, it's important to talk to a lawyer to find out more about your specific situation if it's necessary.
That makes perfect sense. Make sure you know exactly what state you're in and your circumstances, and seek your own legal counsel for the most accurate information. Absolutely. Thank you, Brandon. All right. So, what exactly is a separation agreement?
Right. So a separation agreement, it's a contract between two parties, an employer and the employee. And as the name suggests, it's typically revolving around the separation of employment. So the end of the employment relationship. And typically the intent of a separation agreement is to end the employment relationship as amicably as possible under the circumstances.
Gotcha. And how's a separation agreement different than a severance package? Because I hear those two terms.
Yeah, a lot of people will use them interchangeably, and I think that's okay. Technically, the separation agreement is the actual document that it's the contract between the two parties, and both parties are giving something to the other in exchange. And the employer is typically giving a separation package or a severance package to the employee. Usually consists of a number of items that we'll talk about, I'm sure, over the course of this discussion. And then the employee is giving something in exchange to the employer. And that's so the separation agreement is the document or the contract between the parties, and the severance package is something the employee receives. People talk about them or use those terms interchangeably. And I think in most instances, that's okay. We know what we're talking about.
Got it. Is it fair to say that the details of the severance package okay, let me say that again. Is it fair to say that details of the severance package is in the separation agreement?
Yes, that would be accurate. The actual agreement, the document is going to set forth all of the terms between the parties, including the details of the separation package or the severance package.
Perfect, perfect. Um, I have a list of questions that I wanted to make sure I cover with you because there's multiple parts of this topic that I think is very important. So when does separation agreements usually happen?
So, as the name suggests, it usually happens when the parties are separating. So, at the end of the employment relationship. And I mean, when an employment relationship ends, there is a potential for there to be a lot of downsides. The employee is in a situation where they're suddenly find themselves without the financial security that they had during the employment. And when the employer terminates an employee's employment, then they find themselves subject to the potential for lawsuits. Employee could say they were wrongfully terminated. There's also the potential that both parties might disparage each other, speak badly about one another at the end of the employment relationship if things have really soured. And so there's a lot of potential downsides when the employment relationship ends. And so that's why we typically have these separation agreements. the parties know that they're no longer going to be working together. They know that there's the potential for these downsides, and so they enter into a separation agreement around the time of separation in order to put themselves in the best situation possible moving forward. And so sometimes a separation agreement will be signed by the parties shortly before the employment relationship ends. And sometimes it happens once the employment relationship is already over. And it's clear that the employer and the employee won't be working together anymore, but there's still an opportunity to govern how the parties will conduct themselves and what they will receive and do in the time moving forward. So it doesn't have to be before the separation, doesn't have to be on the day of separation, it doesn't have to be immediately after separation. It could be any of those, but typically it's around the time that the two parties are separating.
Hmm. So right around the time the employee leaves the employer, or they
Exactly.
separate, in essence. So does companies have to give out separation agreements, severance packages?
They don't. They don't.
Hmm.
And I think there's a misconception among some people, some employees who think, that they're entitled to some form of severance at the end of the employment relationship. But there is no requirement that an employer offer an employee a severance package or a separation agreement. It is common in a number of industries and less common in others. So it might really depend on the industry that you're in as to
Hmm.
whether you're going to be offered a separation agreement. It might also depend on how the financial situation of the employer. If they are laying an employee or employees off because they don't have much funds, then they might not be in a position to pay those employees anything upon separation, or the package itself might be smaller than the employee would hope. So it really depends on the circumstances of each case. There is no legal requirement that an employee be paid a severance package upon separation.
Interesting. So there is no legal requirement for the company or the organization to offer separation agreements slash severance packages. Um, is there any requirement that if a company has, let's say the company is going through rounds of layoffs,
Mhm.
just because they offered it in the first round of layoffs, does the company have to offer separation packages in their, I don't know, third round of layoffs?
No, there is no requirement that because they offered a separation package at one point in time that they have to offer it at another point in time.
Hmm.
And it might depend on the specific financial situation of that employer at that point in time. It might be at one point in time they have the means to offer a generous severance package, and it might be later in the lifespan of that company, if it's not faring well, that it might not be in a position to offer um, as rich of a severance package or one at all. So
Mm.
just because a severance package was offered previously doesn't mean that a severance package will be offered to employees in the future.
Wow. So, if I'm understanding correctly, just because a company organization offered severance package a year ago doesn't mean they have to offer it this year. Just because they didn't offer it this year doesn't mean they don't offer it next year. So there's no legal requirement of any kind.
That's correct. The one caveat I would have is that some companies maintain it's like a severance plan. We
Mm.
call it like an ERISA plan that sets forth the terms that kind of bind the company that they are going to provide severance in accordance with the terms of the plan that they themselves have decided to adopt. And if they do have that sort of plan, they generally have to pay out benefits or offer a severance package consistent with that plan. But there's
Mm.
no requirement that a company adopt that sort of plan. And even within the plan that itself, the plan might account for different sort of situations. And so even under the terms of a plan, some sort of terminations might result in a severance package being offered, and then others not.
Mm. I'm glad we covered that because a lot of people assume that companies are obligated to do this. So the other question that I have, because a lot of people kind of assume or think it's not fair uh, when someone else gets a different severance package than they do. I mean, technically, they shouldn't be sharing this kind of information. Um, But I do want to ask you, does a company have to give all their employees the same exact severance package within that separation agreement?
No, so I mean, what we often find, like even in the case of like a single layoff, um, employees might be offered different benefits, or the value of what they might be offered. The severance package might be smaller or larger for different employees who are terminated, you know, on the same day as part of a same reduction in force or the same layoff. And oftentimes, employers will take into account the length of service um, of an employee. So they might be offered more severance if they worked at that company for a longer period of time, and they
Hmm.
oftentimes take into account the employee's level. So if an employee is more senior, there's oftentimes a tendency to offer those employees more severance than someone who is less senior. And so, I mean, there's, you know, it really depends on the employer. That's like a broad generalization, but it's probably true in the majority of the cases that those are sort of the criteria that a company will take into account if they have, you know, sort of a formula for how they're going to pay severance benefits.
Got it. Got it. So, just to recap, companies, organizations are not required by law to offer separation agreements with severance packages. And technically, also, they're not required to give everyone the same separation agreement, although it usually depends based on tenure and level of the position.
That's correct. That's correct.
So, what are some common things that's in a severance package slash separation agreement?
Right. So there are certain benefits that we do see quite often. The most common one is being cash, like some form of cash to help the employee in what is now a difficult financial circumstance. And it's also often tends to be rather persuasive and getting an employee to sign a separation agreement. So the first thing, and probably the most common thing we see, is cash. And that can either be in the form of continuing to pay that employee as if they were employed for a certain period of time. That's sometimes referred to as salary continuation. So even though they're not still employed, you know, if they were previously paid on a biweekly schedule, they'll be continued to be paid on a biweekly schedule for a certain length of time. Or it could be paid as a lump sum, which is just, you know, one
Hmm.
payment paid once, and then, you know, no more future cash payments going forward. So that's probably the most common benefit we see. But other common benefits would include COBRA premiums. So when employees' employment ends under the law, they're entitled to continue to participate in the employer's health plan if they previously participated in the employer's health plan, but they have to pay the full premium after their employment ends. So an employer will often offer to contribute to either continue paying the premium that they paid while the employee was employed, or sometimes the full premium. So that's something we also see quite often. Other benefits might include an agreement not to disparage the employee, and if when they seek references, um, there might be favorable vesting terms for stock. There might be an agreement not to challenge their claim for unemployment. And so those are the sorts of benefits that we typically see. Outplacement is one that's occasionally offered. So that's working with a third party to help the employee, you know, polish their resume and think about how they might position themselves going forward. That's a benefit that the company might offer to pay for the employee. So those are the sorts of things that a company might offer. And if an employee is considering, you know, negotiating a separation agreement and those aren't initially offered, it's something that they can think about requesting.
Hmm. Got it. So, if I'm understanding correctly, separation agreements may include such things as you put it, cash. So that could mean the employee continues to get a paycheck for a certain period of time, or may get sort of a lump sum payment when they separate. Also, COBRA, meaning there may be some sort of benefit of the employee continue to have health insurance that is fully or partially paid by the employer for a certain period of time, is what I'm also hearing. And then also probably some language or some agreement that you won't sue or say bad things about the employer after you leave, kind of thing.
Yeah, so I mean, the I guess the things that I was describing were the things that the employer is giving to the employee.
Mm-hmm.
But to that last point you made, the employee is absolutely going to be giving things to the employer. So they're going to be benefits going in the opposite direction. And the one you just named about agreeing not to sue the employer is probably the most common and the most significant component that the employer is looking for in a separation agreement, which is a release of legal claims. And so it's an agreement to not bring certain legal claims against the company, generally everything under the sun that relates to the employment relationship. Um, there are a few claims that the employer can't require that the employee waive related particularly to discrimination or harassment, but the employer can require that the employee waive any right to receive actual monetary compensation for those
Mm-hmm.
claims. So in most cases, once the employee waives that right, they don't have a great incentive to continue, filing a lawsuit if they can't receive any monetary award. So yes, the waiver of legal claims is the big one that employers want to see in the separation agreement, and that's a big reason why they're offering those other benefits to the employee in the first instance. Some other benefits that flow in the direction of the employer or promises that the employee will make are to not disparage the employer, to keep the terms of the agreement itself confidential, to agree again to maintain the confidential of the information of the employer, their IP, to keep that confidential. There might also be provision in there related to like non-solicitation or non-competition. So it's going to vary
Mm-hmm.
on what the employer's priorities are. But there are going to be a number of promises that the employer is going to be requesting from the employee in exchange for that severance package.
Mm. So what I'm hearing is the organization, company, employer offers a certain amount of benefits, such as a certain amount of cash, certain amount of maybe continued health insurance premiums being paid, things like that. And then in return, the employee is saying, I will not say bad things about the company. I will not sue, etc. So the employer gives a certain amount in the separation agreement, and the employee is also giving a certain amount in the agreement.
That's all right. That's right.
Mm.
And I mean, I'll also mention that, I mean, so this is, the contract that the two parties are entering into privately, but they exist within this greater sphere of employment laws, and these
Mm.
employment laws are always changing. So we have a non-disparagement provision, something that says the employer can't speak negatively about the employer, but the laws are always changing about what an employer can actually limit an employee's ability, to what extent the employer can limit the ability of an employee to speak about the employer, and it changes depending on what administration is in office. And there are other specific terms that in a separation agreement,
Mm.
if an employer wants to enter into this agreement, depending on the state, there might be specific provisions that need to be in this agreement. So those, generally speaking, are the terms in the contract. But depending on the state, or like the specific state in which the employee lives, and the state of the federal law at the time the parties are entering into that agreement, each of those provisions could look a little different.
Mm. Makes sense. One thing I just want to talk a little bit more about is confidentiality. Often in
Mhm.
the agreement, you indicated that there is usually some language in there about keeping the details of the severance agreement
Uh-huh.
confidential.
Uh-huh.
So is this why sometimes I hear things like, "Oh, I signed a separation agreement. Due to a separation agreement, I can't disclose the details. I can't talk about." Is that why people say stuff like that?
Absolutely.
Mm.
Absolutely. And I mean, that's going to be especially common if the parties were actually had like you know a true dispute as to whether the termination was wrongful or not, and there were allegations of inappropriate conduct by the employer, an employer is going to be very aware that the employee feels that way, and they're going to want some sort of clause in there. So one, to not disparage the employer, and then in the case where an employer has plans to offer separation agreements in the future, or plans to they understand that they're going to be terminating employees in the future, and they gave this particular employee a particular amount of money that they don't think they're going to be in a position to give to every other employee who they terminate. They might really care about keeping the financial terms of that agreement confidential, because otherwise every other employee who that employer terminates is going to want a similar package. And because the facts of each case are different, and because the employer's financial ability to pay a severance package might differ over time, it's important to the employer that not all employees know what this particular employee was paid in order to separate under those terms.
Hmm. Whew. So now that we have understanding what a separation agreement is, now that we have an understanding of what some of the more common benefits that may be part of the severance package in the separation agreement, can the employee negotiate these benefits?
The answer is yes, they can certainly try. So this is a contract, and a contract requires both parties to willingly enter into that agreement. And so, if the employer offers um, a severance package that the employee does not find compelling enough to enter into these other promises, they have the option either to just walk away, they don't have to sign it, or they can go back to the employer and say, "Listen, I appreciate what you're trying to do here."
Hmm.
Um, and I am willing to make these promises, but not based on the amount of the cash or other benefits, the severance package that you offered me as of now. Would you be willing to increase that amount? I would accept it for Y amount. And then yes, you could have a negotiation, and then that employer also doesn't have to agree to whatever the employee proposed. And I should also mention that, just as a matter of law, whenever an initial offer is rejected, it's technically off the table. So when an employee comes back with a counter offer, there's no requirement that the employer put back out the original offer,
Hmm.
even even if the employee would have accepted it. And so that's something just to keep in mind.
Hmm.
But sure, the parties are able to negotiate. It just There's no guarantee that they'll ultimately come to an agreement.
Understood, understood. So if I'm understanding correctly, like all contracts, like all agreements, if you get one from your employer, you could either choose to not sign it, which means they don't owe you, that they don't have to keep their promises and the benefits that they're offering to you, and you don't have to keep any promises or commitments that's in the agreement. So both parties just sort of walk away.
That's
Um,
right.
or they could say, hey, I would like to negotiate some of these benefits for what you're asking me in return. And then the employer doesn't have to offer you the additional stuff, doesn't have to negotiate. And when you do negotiate, there's a little risk, or there's risk of them withdrawing the original agreement to begin with. Is that correct?
That's right. That's right. I mean, what I would say is, in the majority of cases, the employer does want to get this agreement signed as well. So, in the majority of cases, what I've found in my practice is that they typically won't walk away from the initial offer, but I have absolutely heard cases where it does happen. So, the majority of times, it's probably not going to happen, but it is a risk.
Mm. Um, How much time do they have to give you to read this stuff over? Like, how
Hmm.
much time do you have to think about this?
Right, right. So this is again like another instance where the law does come into effect. And so if you're working for a larger employer, then they're going to be subject to the Age Discrimination and Employment Act. And that means that anyone over the age of 40 is going to be, they need to receive at least 21 days if they're being terminated
Hmm.
on their own. And if it's part of a group layoff, they need to be given 45 days to consider the agreement. And this is again for individuals who work for a larger employer. If you work for a smaller employer, or if you are under the age of 40, then unless your state has a specific requirement for how much time you need to be given, there's really no set time frame. And I find that employees are typically given, in this case, um, at least usually 7 days. Like I find that's pretty common, but it could be more, it could be less. So it really depends on your age, your state, and then the size of your employer.
Got it. So one of the things that, if you get a separation package, one of the things you should really pay close attention to is how much time you have to review this. Because if you miss that deadline, then what happens?
Right. I mean, if you miss that deadline, then the offer has expired and it's no longer valid. However, again, most employers do want to get this sort of agreement signed. So it's really going to depend then at that like on what the employer wants to do. And the employer might say, okay, yes, we're on day 22. We gave you until day 21, but you're willing to waive your rights to sue the company and you're not going to disparage us. So we'll extend the time for you to review and sign. But other companies, might want to make a point, if they're going to be doing this often, they don't want employees to be taking longer than necessary to execute these. And so they can say, I'm sorry, the offer's expired. You had X amount of time to consider it. And then, the parties just both move on.
Got it. So when you do get a separation package, I'm sorry, when you do get a separation agreement with the severance package in it, pay attention to how much time they're giving you to take a look at it.
That's right.
Because if it expires, then you're sort of in a maybe a slightly more difficult position to negotiate or anything like that. Um, Can you also negotiate how much time you have to review? I mean, if the organization says you have 7 days to review, can you negotiate and say, "Hey, can I have 3 weeks?"
Yeah, I mean, you can ask for that. The employer may or may not give it to you. I mean, oftentimes, they would rather not give employees 21 days to review
Mm,
it, and they're only giving them 21 days because the law requires those specific employees to be given 21 days. And sometimes, they really don't mind. So you can certainly ask. And again, it's just going to be up to the employer whether they want to extend that. And I guess another thing I would mention is that if you are thinking about consulting with an attorney about the agreement, it is going to take the lawyer some amount of time to review the agreement. It's probably going to take you a certain amount of time to find a lawyer that you want to work with. And so I would say, start on day one contacting lawyers if you think you are going to want to work with a lawyer or might want to work with a lawyer, to start doing that early, so that you don't run into any sort of time crunches that would affect your ability to, enter into the agreement in a way that makes you feel comfortable.
hmm. I'm glad you brought up I'm glad you brought that up because when should you consult an attorney and when shouldn't you with these packages?
Right. So I would say that if at any point you feel an employee feels that they're being treated unfairly by their employer, I would say the sooner the better contact a lawyer. This is could be before you've even been, terminated, before the separation meeting has happened. If you feel like the employer is treating you unfairly, I'd say contact a lawyer sooner rather than later, because in many instances, working with a lawyer sooner can put the employee in a better position to pursue their claim than, once they've already been terminated. Sometimes there have been some missed opportunities to put their case in a better position. Um, and then, but if we are talking about the case where, nothing really seemed amiss until the employee, received notice that they were being terminated and was offered a separation agreement, then, that's also an appropriate time to contact a lawyer. And whether, I'm aware that lawyers, charge for their services. And so,
Right.
whether an employee wants to pay for a lawyer is, it's a really a personal decision. And, if, you know, if the employee feels that they understand the agreement, they understand the terms that are being offered with respect to, compensation, and they're very happy and they don't want to pay for a lawyer to review it, that's certainly their choice. But there probably are some provisions in there that will benefit from the review of a lawyer. And the lawyer can also offer some insight as to whether the terms being offered are market or standard, or whether there's an opportunity to put some
Hmm.
terms in there that would level the playing field. And so it's really the employee's decision whether they think getting the value of that insight is worth the cost of the lawyer, and that's really up to them. If they feel that they were terminated under circumstances that were egregiously unfair and perhaps unlawful, and they're considering what's being offered, but they think perhaps they're entitled to more, perhaps they actually want to litigate, then I think they should absolutely contact a lawyer. I mean, some lawyers do only charge on an hourly basis. And so the employee is going to have to decide whether they have the means or the desire to pay that. But there are also lawyers who will take a case on contingency, meaning that they won't charge the employee anything up front, but will rather advocate for the employee to get a certain sort, let's say an increased severance amount, or to take on their case and then take a percentage of the recovery at the end. And so if you are talking with lawyers who do take cases on contingency, um, even if you are in a position where you don't really have the financial means to pay, I think it's probably in your interest to talk to one of those lawyers, because perhaps they'd be willing to take your case on contingency. So I think it's really going to depend. It's a personal decision on whether it's something that the employee wants to invest in. Whether they want to invest in challenging what the employee, I mean, excuse me, what their employer has offered them, or whether they just want to move on with their lives. There's a lot of considerations that go into that, but I think it is at least worth going through that analysis of, would it be in my interest to talk to a lawyer and kind of make that an intentional decision as to whether or not to pursue that.
Hmm. So, you certainly don't need a lawyer in order to review and sign or not sign a separation agreement. But if there are parts of the separation agreement or the severance package that you feel like you don't fully understand, or that seems unfair, or that you have questions about, then it may be a good idea to maybe consult with a lawyer. And I'm also hearing the lawyer could charge you an hourly rate, or could take a certain percentage at the end of the negotiation period based on what you get. Make sure you ask the lawyer what fee structure they use. Is that what I'm
Exactly.
hearing?
That's right.
Um, so, Brandon, what are some negatives about possibly hiring a lawyer? Like, people say things like, oh, when you hire a lawyer, your employee thinks you're out to get them, and they may not be, may not feel as good about the relationship as they may have. So, what do you say to that kind of maybe feeling or understanding that if I get a lawyer, the employer thinks I'm out to get them?
Yeah, I mean, you know, the first step would be to talk to the lawyer one on one in an attorney-client privilege conversation.
Mm,
The employer doesn't even know that you're having that conversation, and so you could
good
talk with
point.
that lawyer. One, just to understand the separation agreement, what the terms mean. In most cases, an employee who doesn't work on separation agreements all the time isn't going to know what they don't know, and so they can
Mm,
just have that conversation, and they might very well decide, like, they're comfortable with the agreement, or they're just going to ask for a few tweaks, and they can have
right.
that conversation with their employer on their own without like the lawyer's existence ever really being shared. um
Hmm.
or in some cases an employee is actually quite dissatisfied with what they've been offered or what they've been treated, but they don't want to escalate it to involving their lawyer. And so they can talk with a lawyer about strategies for they themselves
Mm,
to request changes or how to negotiate it without the lawyer actually, being the one to engage in those negotiations. And in some
mm,
cases, an employee feels incredibly aggrieved, by how the employer has treated them, and the ship has kind of sailed on there being like a kumbaya moment between the employer and the employee. And they do want a lawyer to represent them, to let the employer know, not necessarily in like a personal sort of way, but just as a matter of business, that they expect more severance for what's being offered, or that they do believe there has been some form of wrongdoing. And a lawyer should be able to channel the sort of ethos of that employee. And there's a way for a lawyer to communicate with a company, an employer, in a way that doesn't have to be overly antagonistic, but
Mm,
can simply just present to that employer the perspective of the employee in a way that employee might be a little too close to the whole situation to be able to communicate their feelings, their perspective, in a sort of a more dispassionate sort of way, because there are such intense emotions involved when your employment has
mm,
been separated. And then there might be other
mm,
cases where the employee really does want the lawyer to get across that the employee feels extremely aggrieved, and that there is a big expectation for something more to happen here in order for this to be resolved. So
mm,
it's really important for the employee to work with a lawyer that they think can appropriately communicate with their employer in a way that represents their viewpoint. Different employees, different people have different ways that they want to approach these matters. Different lawyers have different styles, and that's okay. And so, there are plenty of employment lawyers out there who are very qualified. And so it's worth finding a lawyer that you feel like you identify with and can represent you in a way that, you
mm.
feel confident and comfortable with the engagement.
Got it. Got it. So it sounds like you could always consult with a lawyer and to just talk through the possibilities of working with the lawyer, and your employer would never know. So it
Mhm.
never hurts to kind of have a consultation to see if this is something you want to get a lawyer for. And secondly, there may be times where if there is a lot of emotions involved, having a lawyer speak for you may actually be helpful because they can be neutral and a little bit more factual than perhaps you can be because you may be very emotional about this topic. Understood. So speaking of getting lawyers, it seems to me a lot of people just assume get a lawyer, and it doesn't really matter what type of law that
Mhm.
lawyer sort of
Mhm.
specialize in, kind of like just get a lawyer. Just seeing the lawyer's letterhead will
Mhm.
will be enough. With severance packages and with separation agreements, what kind of a lawyer should you look for?
Right. And I think in this sort of scenario, it makes sense to talk with an employment lawyer, or a lawyer who, some lawyers have several specialties, and one of those is employment. But you should be talking with a lawyer who routinely negotiates and reviews separation agreements, because there are many lawyers who specialize in this. It doesn't
Mm,
make sense to talk with a lawyer who doesn't have that level of familiarity with the law, the market, the way these cases are handled. You might have, a family relative, for example, who, sort of has like a more generalized practice or a different specialty, and you might want to leverage them. But a company will, they oftentimes have either their outside counsel or their in-house counsel, and they're going to be able to tell whether the lawyer they're dealing with has a good understanding of the way these separation
mm,
agreements work, where they have a good understanding of the way the law around employment generally works. And so, for that reason, I think it makes a lot of sense to speak with a lawyer who specializes in this sort of work, because those lawyers are out there, they're available. And so, why not speak to the most qualified lawyer when reviewing these sorts of agreements?
makes sense. Makes sense. I mean, when you are buying a house, you probably want to talk to a real estate lawyer, um,
Exactly.
not an employment lawyer.
Right.
And when you're talking about severance
Yes.
packages, you probably don't want to hire a lawyer who specializes in real estate, right?
Exactly.
Um,
Exactly.
so in this day of hybrid working, if
Mhm.
you're looking for a lawyer, should you find a lawyer? Because earlier you said you practice in Massachusetts, for
Mhm.
example, and laws are different based on different states. So if I'm a hybrid worker, should
Mhm.
I get an employment lawyer that practices in the state that I live in, or should I get an employment lawyer that practices where the company headquarter is?
That is actually like a pretty tricky question. And I
Okay.
mean, I I generally advise getting a lawyer in the state where you live,
Okay.
because I was saying most of the employment laws relate back to, they tend to protect, states try to protect their own sort of residents, and so if you live in a
Mhm.
particular state, most laws are going to protect you. But there could be certain cases where the employer is subject to certain laws just based on the state where they live.
Mhm.
Oftentimes, the contract could have a provision in it that specifies a choice of law. I think in most cases, it probably makes sense to speak with a lawyer in the state where you live. I think that's generally the approach that I would recommend.
Mm, makes perfect sense. Um, One of the things that I want to do with our audience is make sure that they get practical information. So, how much does a lawyer typically charge on an hourly rate? So they have some understanding of what they may be getting into if they hire a lawyer.
Right. I think the range does vary, frankly. I mean, we talked about contingency, so no, that's just going to be a percentage of a recovery, and so that kind of is what it is. And then, the hourly rate, it can really vary. I would say between probably $300 to $600 an hour, somewhere in that range, is probably where most employment lawyers who represent employees are likely to fall. So if you're, if a lawyer has offered some terms that are within that range or close to that range, I think that's probably fair. There could be some that are lower and some that are higher. I myself haven't done a sort of like a survey of how many,
Of course,
of
of
what
course.
different law firms charge. But I feel like somewhere in that range is
Mm.
probably fair.
Okay, makes sense. If someone's charging you $50 an hour, you may ask yourself what kind of a lawyer you're getting,
Yes, yes,
right? And if
absolutely.
someone charges you, I don't know, $1,000 an hour, you have to ask yourself, is that worth the actual package you're getting from your
Right,
employer?
right, right, exactly.
Understood. Understood. All right, we covered a whole bunch of things, and I'm looking at all the different questions that I wanted to make sure I ask you. Is there anything that you feel people should know about when it relates to severance packages and separation agreements that we haven't talked about yet?
I think we pretty much covered most of it. I guess like if I were to just like off the cuff say is like, it's a pretty emotional event. We're talking in like legal
Yeah.
terms and like strategy, but like I just want to acknowledge that it's like a very emotional event. And so I think like when employees are going through a range of emotions, they should just acknowledge that that's normal.
Yeah.
And when if you do talk to a lawyer, they're going to be very prepared for that. And hopefully we'll be able to help you, guide you in a way that puts your best interests forward. And I guess another thing I would mention is like along with those emotions, like this is for most people, this is typically, not the end of their career. I know it sometimes feels that way, but it's like it's just a step in one's career. And
Mm,
so I think it's just kind of like thinking from a business point of mind strategically, how are we going to navigate this one step? And, then, pretty much everyone will land on their feet thereafter. And so I just want to kind of acknowledge that it's a
mm.
strange time for any individual to be in. And, you know, it's not the end all be all of one's career.
I'm so glad you said that because, jobs are a huge part of our life. And anytime any relationship comes to an end, there's a lot of emotions and it could feel very, very traumatic and sort of acknowledging that and knowing that there will be another job career after that is
Mm.
something always good to keep in mind. Thank you for that. I realized there's sort of two follow-up questions that I didn't get a chance to ask you. And one is to sort of clarify when a separation agreement can be offered. So generally speaking, separation agreements are usually offered when employee and the employer are parting ways,
Uh,
separating, right?
okay.
What are some reasons for that? So one, we talked about layoffs, org restructuring, staff reduction, things like that. What are some other things that could be causing the employee and the employer to be separating?
Right. So, I mean, true, like a very significant or common instance is a reduction in force, a layoff, like reduction in headcount. But it could also just be that, that particular employment relationship, it's turned out to not be a good fit. And some employers have a practice of somewhat routinely offering separation packages when there are performance concerns in order to sort of to have that amicable end to the relationship, and not have it be especially acrimonious. In other cases, the employee, over the course of their employment, might have felt that they have been treated unlawfully in some way. They might have been discriminated against. They might have been harassed, and they don't feel that they can effectively continue working in that employment relationship anymore. And the employer, whether they agree or disagree that the employee was treated wrongfully, can also acknowledge that this is no longer a fixable situation. And it might be best for the parties to part ways. And given the circumstance under which it's ending, it'd be best to have a separation agreement so that the parties can truly both go their own separate ways without this being a lingering issue.
Got it. So in addition to staff reduction, layoffs, and so forth, separations could also come up when the employer wants to proactively part ways with the employee.
Right.
And it could also come up when the employee proactively wants to part ways with the employer for a variety
Exactly.
of reasons.
Exactly.
Um, so I'm curious. One of the second follow up question is: can the employee ask for a severance package when they're not offered one?
And the answer is yes. I think it certainly is much more common that the employer is offering one to the employee, but an
Mm,
employee can absolutely present that to an employer, kind of for the same reasons we've discussed, in order to amicably part ways. And I mean, if there are allegations of misconduct by the employer, that might be a reason why an employee propose a separation agreement, kind of with the understanding that if there is not an agreement, there's going to be some sort of consequence, down the road, like they intend to file a lawsuit unless there's a separation agreement. Um, so yes, an employee can offer one, and the employer might take them up on it, or the employer might say, no, like, you've told us that you're resigning, and we wish you all the best, but given that you're resigning, you know, we don't offer separation agreements in that context. So an employee can ask for one, and I think the circumstances under which the employee are leaving is going to make that request more or less compelling.
understood. And I was looking at my list of questions. How could I forget? Does severance packages impact the ability to collect unemployment?
So I believe that is really going to depend on where the employee lives and their state. I would say in
Mm,
Massachusetts, generally, a severance agreement does not affect the employee's ability to collect unemployment, at least as of the law, as of the time of this, recording.
hmm
So that's great for employees in Massachusetts. It's really going to depend on the state in which the employee lives, I believe.
got it. All right. As we end, last words of advice to folks who may be getting severance packages?
I don't I think we really covered it all. So I don't know that if I have anything else to add. I mean, I've really enjoyed the conversation, and I'm excited to be here, but I think that covers it. You asked a lot of great questions. I don't think I can do better.
I'm so glad. Um, well, I am so, so happy you joined us today, Brandon. And for those of you who are interested in how to reach Brandon for his employment law expertise, his contact information will be in the description below. We'll list his website and other ways to reach out to him. I have worked with Brandon in different stages of my career, and I've always found his advice to be incredibly practical, simply worded, easy to understand, and Brandon always does have the his clients in mind. So thank you, Brandon, for
Oh,
joining us
it's a
today.
pleasure. Thanks, Sue.
So today it was all about severance packages, separation agreements. Hope this was helpful. If information and content like this is helpful, please like, share, subscribe. And once again, thanks for joining Jobs and Careers with Sue. See you next
Thank
time.
you. Bye.
Thank you, Brandon.